Hey, what's going on? I got a weird one for you today. You know, when I say weird, people panic. So, this is a crazy estate case, I guess is what it would be classified as. Um, I don't even know where to start. So, we're in Kansas, and a gentleman died, and the people in his will had already died. So now there is a battle amongst his heirs on who gets his, um, it's just under $1 million estate. And it is crazy, absolutely crazy. A little drama filled, a lot of legal education. And I don't like estates. I don't like any of that stuff. Worst class in college was wills, trusts, and estates. Oh, I hated that class so much. It was horrible. But we will talk about this will because I have read through every single page of every single filing, and there are a lot. Wow. Like lots of citations, lots of Judge Ricke's got to be loving this. Seriously. Okay. So the reason I'm going to talk first is because if I don't give you some background information on what happened on paper leading up to this point, you will be totally lost going into this hearing. I was the first 3 times I watched it until I read everything. Then it kind of made sense to me. So real quick, before we get into the actual case, let's talk about when you die without a will, intestate. There are statutes in almost every state that says what happens to your assets, what happens to your stuff, who's going to get that $3 worth of change that's, buried in my couch, because that's about all I'm worth these days. So generally, things pass to your children or your parents. After that, it's going to be your grandchildren, brothers and sisters, maybe grandparents. So nieces and nephews would be after grandchildren, children, brothers and sisters, parents, grandparents, and they'd be in line with great-grandparents and aunts and uncles, if that makes sense. So now that you know that, let's look at their family tree real quick, because this is where it gets a little wonky. So Ma and Pa had 3 boys. And then Ma had another boy with someone somehow, somewhere. I didn't get into all that. So Larry, who we're looking at, he had 2 kids. His brother, Dennis, had 1 child. And then the half brother, Ma's kid, but not Pa's kid, had a daughter. But that daughter was possibly never legitimized. So there's no definitive proof that she's really his daughter. They weren't married. She was born out of wedlock. There was no, they say legitimized. It's such a crappy word, but basically you got to go through the court system, put it on the birth certificate, and pay child support. I don't know. So when Larry wrote out his will, this is Larry's will, he left everything to his parents. So he wanted Ma and Pa to have it all. They were living with him at the time. He wanted them to have everything. Now, he wrote this will out back in 1999. He wrote in the will, I understand I have 2 children. I do not want to leave them anything. Like, point blank, you get nothing. Nada. Sorry, nothing. All 3 of Larry's brothers passed away before him, as did his parents. He has disinherited his children. So what that leaves is his grandchildren, his niece, and his possible half niece, maybe. Yeah. So those are the people. This is our cast of characters. So hopefully that will help you understand this.
This is in the District Court of Butler County, Kansas, case entitled, in the matter of the estate of Larry Franklin Holderman, deceased. It is case number 2022 PR 168. The court finds that Trent Weta appears, attorney for the estate. Mr. Cranmer, would you make announcements, please, regarding appearances?
Yes, Your Honor. Douglas Cranber and Sam Natera of Stinson Wilson on behalf of Frank Blunt, Esme Pearl, Sam and I are appearing via Zoom video from my conference room. Frank and Esme are appearing via Zoom video from, I believe, the state of Washington. And you can see their pictures on the Zoom video.
All right, Ms. Williams?
Yes, Joy K. Williams. I am accompanied by my client, Susan Davenport. We're appearing via Zoom.
Mr. Mills?
Your Honor, Russell Mills appearing on behalf of my client, Mandy Holderman, a heir and issue of the deceased. She is present in my conference room with me.
Okay, Mr. Mills, can you tilt your screen just a little bit? I can just barely see your heads. There you go.
Oh, okay.
Thank
Sorry
you.
about that.
I appreciate that adjustment.
Okay.
There appear to be no other appearances on the meeting. We will begin. This matter is set for further proceedings after the court had conducted a previous hearing where construction of the will was extensively discussed. I will note, as I'm sure the attorneys are aware, that Mr. Mills made a very belated filing yesterday of an interpretation of will and application of anti-lapse.
I'd like to introduce you to a new segment called Penny Explains. So we all know sometimes dogs are smart as a whip, other times they're dumb as a box of rocks. Reddit might explain it like I'm 5, but here we're going to explain it like we're a dog. So here, for the first time, Penny's going to explain the Kansas Anti-Lapse statute, which is actually really simple, but comes across as really confusing. So Kansas Statute 59-615, also known as the Anti-Lapse statute, reads, devise or bequest to spouse or relative who predeceases the testator, issue, defined. If a devise or bequest is made to a spouse or any other relative by lineal descent or within 6th degree, whether blood or by adoption, and such spouse or relative dies before the testator, leaving issue who survive, the testator, such issue shall take the same estate which devicee or legatee would have taken if he or she had survived, unless a different disposition is made or required by will. It's further broken down in the annotations as anti-lapse statute in effect at testator's death, applicable in action to determine whether heirs of deceased beneficiary succeed in his interest in re-estate of Thompson, which is still really confusing. So let Penny break it down for you. Okay, so let me give you a scenario. When we went to adopt Roxy, her littermate Lola would not shut up, crying, screaming, having a fit because we took her sister away. So we ended up with 2. They were inseparable for about a week. Then we get home and Lola disses Roxy for Rambo. Now her and Rambo are obsessed with each other. Her and Rambo have a love-hate relationship. He beats the crap out of her in the morning and then loves on her in the evening. It's like an abusive relationship. It's really bizarre. Anyways, so Rambo has his favorite toy ducky. So he writes out his will and leaves his favorite toy ducky to his girl, Lola. But Lola's scared of everything and ends up having a heart attack when someone looks at her, and she's gone before Rambo. Lola doesn't have a will, so everything she has passes on to her sister Lola. It's like a dog, except Rambo's toy ducky. Because per the rules of the anti-lapse statute, items can't pass collaterally, they have to go lineally. Lineally means up and down, collaterally means across a generation line. So, say during her, week at the pound, Lola hooked up with Stray, had a kitten. Rambo doesn't know about this kitten, doesn't even know it exists. However, this kitten is getting Rambo's ducky toy because of the rules of the anti-lapse statute. What it means is that the inheritance automatically passes down to a person's descendant, whether it's specifically stated in the will or not, unless it is specifically stated otherwise. Hopefully that explains it just a little bit. I don't know.
The title. I trust each attorney is now familiar with Mr. Mills' recent submission. We are here to discuss the status of this matter and for the court to make some ultimate rulings in the case. I want to give each attorney an opportunity to at least make a summary statement of their current position in the matter. I will start with Mr. Mills.
Your Honor, I apologize for the delay in getting my response to your request completed. I will tell the court that I spent a great deal of time trying to comply with the court's request, which as I understood it. And so the document that I have filed is pretty much sets out the law and the facts as I understand them. Now, Your Honor, I want to make sure that the court understands that the facts that my client has provided to me are facts that are essentially from her family history, and I don't want to mislead the court in any way. But it's our understanding, or her understanding, that the children, Frank Bly and Esme Pearl, were adopted by a gentleman by the name of Mr. Bly. And so in the first part of my written presentation to the court, I kind of go through that and how that might affect these proceedings. And if we can confirm through Mr. Bly that he was in fact adopted, I mean, it just makes sense to me if he goes by Mr. Bly that someone named Mr. Bly did in fact, adopt him. That being the case, Your Honor, we believe that the law of the state of Washington would impact this case greatly as it relates to the adoption.
I don't quite see how, Mr. Mills. This is a Kansas drafted will that's being probated in Kansas. So why should this court look to law of the state of Washington here? I noticed that in your recent submission that if Kansas law didn't appear to be on your side, you cited Arkansas law or Washington law or some other state's law, perhaps to avoid the implications of Kansas law, I would suggest.
Well,
why Washington?
Your Honor, I guess the main thing that I think we have to keep in mind, Your Honor, is that the Kansas law, even in interpretation of the wills, we're supposed to determine what the intent of the testator, and even under the Anti-Lapse statute, that's there for the purpose of helping to us, or focusing us on, again, the intent of the testator. And so what I'm trying to advise the court of is if you look at the statutes, you can't on the one hand say, well, he should be aware of the Kansas law, but not be aware of the Washington law that terminated these children as his children, and further terminated those children as having any right to inherit from him. So that was something that he would have known and would have taken into consideration when when he was involved in this will here. I think that if that's the case, I don't think the Kansas court can determine that these children or even their grandchildren were in fact issue of my client's father, of Esme Pearl and Frank Bly's father, or the grandchildren of Mr. Larry Holderman, or issue either for the purposes of the Anti-Lapse statute. So, if we're given full faith and credit to the orders that were entered in the state of Washington to the adoption, then that just takes them out. So that's kind of my position on that, Your Honor. But it further goes to the intent of Larry Holderman, the testator, as to whether or not he wanted to include these people. And the facts that I was given by my client, or I should say that the history, is that Mr. Holderman, after the adoption, never saw, well, I should say, as I set out in my pleading, only saw Frank Bly one time in his life after the adoption, and only saw Esme Pearl twice in his life after the adoption, and only saw the grandchildren that were born at that time once during his entire life. So when you take that type of information into, looking at, well, what was the testator's intent, I think that this information is very important for the court, because the court, under the case law that I've presented here, says that the court, in interpreting the will, needs to place itself in the position of the testator as closely as it can. So in order to do that, the court needs to know, what the kind of the family dynamic was at that time. And so I felt that the case law that I've provided does point the court, in that direction. And once you do that, Your Honor, then you can look at the facts and easily, in my opinion, determine that Mr. Holderman's intent was to disinherit his children, which is absolutely set out in the will. I mean, there's just absolutely no other way to interpret the will.
Let's talk about that for a second, Mr. Mills. If earlier you were arguing that he was relying on Washington law that would apparently, under their statutes, automatically disinherit adopted children, then why did he mention them specifically in his Kansas will?
Your Honor, I think
if he was relying on it, he wouldn't consider them at all, would he?
No. And here's what I'm saying, Judge. This is a very good point that I think you're making, and I think I have the answer. Because, Your Honor, I think all of the attorneys were not aware of this situation. And certainly I wasn't. I can't speak for the other attorneys, but I was not aware of this adoption until I just, got to looking at Mr. Bly's name, and I kept thinking, why in the world is his last name Bly? So I called my client, and then that's when, for the first time, I figured out about this adoption, and I wanted to bring that information to the court. I think that maybe what happened was when Mr. Bly went to have the will signed, the attorney said, well, do you have any children? And he may have said, well, I had some children out in Washington, and maybe he didn't tell him that they were adopted, just as we've had a kind of a problem here with getting that information to all counsel. So I can see where I know if I had heard something like that, I'd say, well, let's just make sure we disinherit them anyway, just to kind of cover all bases. And so I think that's probably what happened there. And I think the fact that we've, been involved in this situation for quite some time, or this place for some time, and no one brought up the fact that these children were adopted, kind of speaks to that very issue.
All right. So, Mr. Mills, let me ask you this question first. Your client, Mandolin Holderman, is not mentioned as a beneficiary under this will. Would you agree?
I would agree, Your Honor.
So why is she entitled to anything under this will if she's not specific?
Well, I think what you have to do, Your Honor, is you have to look back at the facts and understand where Mr. Holderman was in his life and what had happened.
Okay, put that aside. Put that aside, Mr. Mills. I don't need an exploration of what he might have been thinking about. I just want to know, as a matter of law, why are you taking a position that your client's entitled to anything under this will?
Anti-Lapse statute, Your Honor.
59-615?
Yes, clearly
which says what? Summarize it for me. What does it say?
It basically says, Your Honor, that when a relative who is the named beneficiary or devisor, when they are named in the will to receive, and they predecease the testator, but they leave surviving issue, then in that event, those surviving issue will take what the deceased beneficiary would have taken. And so there's no dispute that my client is a issue of these grandparents. And so she would take what the beneficiaries who were deceased would have taken. And so there's no question about that.
All right.
The question.
Okay.
Go ahead.
Thank you, Mr. Mills. I appreciate the summary explanation of the Kansas anti-lapse statute. We'll be getting back to that. So did you have any other presentation or argument that you wish to make at this time?
Well, Your Honor, I would just refer the court back to my brief that I think, well, it's not brief, but I mean my pleading that I think goes through the law pretty clearly, and I will say I understand it, that the court and counsel got it maybe a little bit untimely, but it certainly I did the best that I could to get the law to the court, and I think if the court reviews it, it will have the law that it needs to reach its determination.
Thank you, Mr. Mills. Mr. Cranman.
Thank you.
Thank you, Your Honor. I did receive Mr. Mills' pleading, however, I think it was filed around noon or so yesterday.
What they keep referring to about Mr. Mills' filing is back on 7/7 when their prior hearing took place, apparently Judge Ricke ordered Mr. Mills to write something up regarding the anti-lapse statute and how it applied in this case. And he did not submit it until yesterday, middle of the day, which meant most of the attorneys did not get it till last night. It was a multi-page filing with quite a few citations and a lot of information compiled into it. So obviously they haven't had time to fully review it, to prepare any kind of answer for it. So they're all a little upset that they received this at the last minute when he had a month and a half at least to prepare it.
I had court yesterday afternoon, so unfortunately I didn't get it forwarded out to my clients until last evening. They have told me this morning, and they had sent me an email, I haven't spoken to them, that they were not adopted. It is true that Mr. Holderman, the decedent, and the Frank and Pearl's mother were divorced, and she remarried to a man named Mr. Bly. I can't remember his name. I am told, and I asked my clients about this when the case first started, why was his name Bly? And that's when they explained to me that their mom had remarried to a man named Mr. Bly, and they had done a name change. And they specifically indicated at that time that it was not an adoption, it was a name change. And they reiterated that via email to me this morning, that they were not adopted. This was some sort of a name change action that took place up in Washington State, not an adoption.
Mr. Kramer, under Kansas law, is that a difference that makes a difference? Or
I don't think it does make a difference.
Adopted children still entitled to inherit from a natural parent in Kansas?
In Kansas, I believe they are, and that was kind of where I was leading into. I mean, the next Mr. Mills' pleading then goes into talking about Alabama law and Arkansas law and things like that. Well, I don't believe that's the law of the state of Kansas. I believe an adoption does not cut off the right to inherit unless it specifically says so. And again, I didn't have a chance to look at the law up on that due to my late receipt of Mr. Mills' pleading. So I really don't think it makes a difference, but I just wanted the court to know that it's my understanding from my clients that they were not adopted. They just had a name change, and that's it. So I will just highly summarize our position, Judge, and of course I would welcome any questions you might have. But I think the case of Estate of Strobel, 6 Canap 2nd 955. It's a 1981 case, and the Kansas Supreme Court denied review of that in on January 20th of 1982. The Strobel case facts and the facts of this case are nearly identical.
To say the two cases is identical is a huge stretch, in my opinion. However, he doesn't really give you any background on the Strobel case, so let me tell you what it's about really quick because it's really interesting. So Miss Strobel was a Kansas woman back in 1978. She had kicked her husband out, was in the process of getting a divorce. She moved her mom in, and her mom was living with her. She did what she was supposed to do. She revised her will. She said, I want to leave everything to my mother as long as she survives me by 30 days, and I don't want my husband to get anything. Somehow, she left her car running in the garage of the home that she shared with her mother. Both her and her mother died of asphyxiation and carbon monoxide poisoning. This is where a legal battle ensued over her will. Her husband thought he was entitled to everything, and there was no backup beneficiary listed. There were two provisions of her will that caused an issue. It was her mother had to survive her by 30 days and her specifically eliminating her husband. This basically eliminated any of the family heirs from inheriting her estate. To overly simplify the conclusion, she basically wasn't able to exclude her husband from her inheriting in her will because she didn't have anyone else to leave her property to.
In that case, the Strobel attempted to disinherit a relative. In that case, it was her husband. In this case, the decedent attempted to disinherit his children, Frank and Pearl. In Strobel, the intended beneficiary, who was in that case a decedent's mother, did not survive the decedent. Well, the same thing happened here. In this case, the intended beneficiaries, who were the decedent's parents, predeceased the defendant. So in the Strobel case, the will did not contain a residuary clause. In this case, the will did not contain a residuary clause. In Strobel, it was found that a decedent cannot disinherit his heirs by words alone. So in order to disinherit his heirs, the property must be given to somebody else. And it wasn't. There was no residuary clause. That was it. That's the same thing that's happened here. The property has not been given to anybody. The gift away from the purported disinherited people has not been completed. And that was found to be not a good disinheritance. In Strobel, it was found that where a bequest lapses because of the death of the beneficiary prior to the death of the decedent, and there's no residuary clause in the will, the property subject to the lapse bequest passes under the laws of distribution as intestate property. And we believe that's exactly what the court should find in this case. It's exactly the same thing. And therefore, the anti-lapse statute does not apply to property that passes via intestate succession or under the laws of descent and distribution.
Okay, Mr. Kramer, let me stop you there. What precondition did Franklin and Clara, the primary beneficiaries under this will, what condition did they fail to meet?
They didn't well, it's implied that they need to survive the decedent in order to be able to take his under the will.
But isn't that exactly where the Kansas anti-lapse statute is intended to step in?
But
Strobel, it would seem to the court that Strobel's different in that case, the primary beneficiaries had to meet a condition, which was a survival condition. That language does not exist in this will. Doesn't that make Strobel factually distinguishable from this current case? You say they're exactly the same, or you're suggesting they're exactly the same, but the reason why there was a lapse in Strobel is because the precondition wasn't met. There was no precondition here. And while it's true that Franklin and Clara didn't survive the testator in this case, that's not an unusual situation. The legislature's contemplated it and passed a statute that steps in, does it not, and say, well, if there's any lineal descendants, there's no lapse. Isn't that true?
But again, I think that's a distinction without a difference, because I think the implied condition is that they have to survive the decedent in order to take under his or her will.
Well, if that's true, then the anti-lapse statute has no meaning at all.
Well, it goes by.
Mr. Mills has consistently argued from the beginning here.
I think that it under Strobel, the will failed. So therefore the anti-lapse statute never applied.
Right, so let me ask you, how did the will fail here? Yes, the testator in this case, for whatever reason, left his estate to some people much older than him. It's certainly possible that somebody older than you isn't going to survive you, but that those individuals that received the benefits of this will left issue. So isn't that exactly a Kansas anti-lapse statute situation? But
because the gift was not completed, in other words, there was no residuary clause to apply, it passes outside the will through intestate succession. That's why I say the anti-lapse statute does not apply in this case.
All right. Okay. All right. And if that's the case, then who would be the beneficiaries of this will, or who would receive this estate is the better question. Who would be the ultimate beneficiaries of this estate if the court accepts your argument, Mr. Cranmer?
It would be my clients, Frank Bly and Esme Pearl.
Okay.
And that was the same way it was in Strobel. And the other case I'm relying on is In re Estate of Hainberg, and that's 270 Kansas 365. And again, that's another case. It's not, there was not an attempt to disinherit anybody, but there was no residuary clause in the will or the codicil to the will, and give to an heir lapse in that case, and it was deemed to pass under the laws of intestate succession, not under the anti-lapse statute under anti-lapse.
All right.
Those are the two cases, and I would point out that the two cases I'm relying on for the most part are more recent cases than any case that anybody else in this case is relying on, and they still remain good law in Kansas. I think the court's pretty familiar with the rest of my arguments from last time, so I just wanted to summarize everything for you.
Thank you for your concise summary.
Questions, Your Honor,
I understand your position today. Ms. Williams, what position do you take here?
Yes, Your Honor. I did a great deal of case research, and my understanding of the question that the court was contemplating was basically if, when applying the anti-lapse statute, if we could do a generation skip and skip over Frank and Esme Pearl, who otherwise would have been beneficiaries but were disinherited. I can tell you there is no case law out there. As far as I can tell, nothing in Kansas, nothing in any other state, just simply nothing on point. What I did start realizing as I'm researching, there is a definite theme, and that is a disinherited person can inherit through intestacy. If intestacy applies to a situation, then that's when the disinherited person can come back in. But where the anti-lapse statute is being applied, I saw nothing where they were able to skip a generation over a disinherited generation and go to their issue. So I very much disagree with Mr. Cranmer's interpretation of Strobel. I think his interpretation would do away with the anti-lapse statute altogether. This is not a case where intestacy law should be applied. It's an anti-lapse statute. My client and Mr. Mills's client would be the grandchildren of the two original beneficiaries. Since neither of those
is that conclusive at this point factually?
Not.
Do you have documentation?
It is still a disputed fact that we're going to have to take up, Your Honor. And I don't know if you want me to get into that now, because that's a whole nother conversation of where we are on that.
No, not particularly, because
okay. Yes, but that is something that we're still working on. Yes, but we believe that my client will be one of two heirs. I don't believe that just because the two original beneficiaries are deceased, that somehow we can apply the law to bring in those two disinherited grandchildren, Frank and Pearl. To get to their children, you'd have to generation skip, and there is nothing that I can find in any case law or statute Kansas or otherwise, that would allow for that. And that is the distinction I started realizing that I was seeing, that I couldn't find a fact pattern such as the one before us. But all the fact patterns where a disinherited person was brought back in was under the laws of intestacy. So I think that is a significant distinction. I think also where you have the anti-lapse and where you have disinherited folks, the testator's intention has to be supreme. Now, I don't know if they were, if Frank and Pearl were actually adopted or not in the state of Washington. That obviously makes a difference. If they were adopted, though, I do think, even though this is a Kansas case, the Washington statute under which they were adopted says that, unlike Kansas, you don't inherit from your biological family once that happens. And I think that law would dictate if they were heirs or not, if they were considered legal relatives of Mr. Holderman anymore. However, it sounds like that is in dispute. Even if they were not adopted, I still don't believe under anti-lapse that they can come back in to the into the will as beneficiaries, because they were clearly disinherited, which is allowable. And I believe Mr. Holderman did exactly what he had to do to disinherit them. So I don't believe we can revive their standing. And I think because we can't revive their standing, and there are two other people in line to inherit, that we can generation skip and then bring in the great-grandchildren to inherit. So that is, I think, what I believe is that we have to apply the anti-lapse statute. And so it comes down to Mr. Mills' client, and I believe to my client at the end of the day.
All right. Thank you, Ms. Williams.
You're welcome, sir.
Mr. Weta, do you take any position here on the will construction issues before it?
Thank you, Your Honor. It's difficult for us to take a position at this point. We have my client has a fiduciary duty to the beneficiaries, and right now we're trying to figure out the beneficiaries. I will say that I think that there's been a lot of case law put here today. I spent some time with Mr. Mills's submission from yesterday, and I would beg to differ with his characterization that it pretty clearly lays out the law. I don't think there was anything clear about the pleading. It was remarkably difficult to get through because it was a mixture of both law and fact. And they call them uncontroverted facts, and I don't believe that those facts are uncontroverted in any way, shape, or form. And I think he admitted that today on the record when he rolled back his and said that it was family history instead of uncontroverted facts. To that end, Your Honor, our position remains that we will do what the court tells us is required to do. We do think that the court should apply 59-615. We do believe that this situation does apply to that circumstance. We disagree. My personal interpretation of the statutory language disagrees with the others who are asking to apply 59-615. 59-615 specifically states that if someone qualifies to receive the gift and predeceases and leaves issue, that issue should take, and that the issue of the individuals who were given there are, at least to the best of our knowledge, the four individuals that are put here in front of you: Frank, Esme, Joy's client, and Mr. Mills's clients. We think realistically that the grandchildren shouldn't take, but if the court were to interpret the statute to say that the disinheritance requested in the will still requires that Frank and Esme be disinherited, then I believe our position is still that looking at testator's intent, he did not make mention of any grandchildren or any issue of those two individuals in his disinheritance, and therefore the court cannot presume his intention. The court can only determine his intention from what was put down in the will itself. And so to that end, that is our position. But at the end of the day, my client is not a beneficiary of this estate, and frankly, just wants to ensure that she is complying with her fiduciary duties to all of the beneficiaries going forward. Thank you.
Thank you for your concise statement of position, Mr. Wenham. Court's prepared to rule on issues in this case at this time, and I do appreciate the time and effort by all the attorneys involved in this case to make their positions clear. This has been at least an interesting and fascinating exercise in the law for this court. For anyone who might be watching YouTube today and essentially participating in the public viewing of this public case, court wants to go over some basics in this case. The decedent, the person whose will is at issue here, is a fellow by the name of Larry Franklin Holderman. Larry Franklin Holderman did a will, I think in 1999, that contained a specific provision that he's leaving his estate to his parents, Franklin and Clara. In the third paragraph of that will, he makes it quite clear in the view of the court by stating, I am aware that I have two children, namely Terry Robertson, also referred to here as Esme Pearl, and Frank Bly, and it is my will that neither child inherit under my will. As might be expected, when interest in an estate is left to persons older than the person making the will, Frank and Clara both predeceased Larry. In other words, his parents died before he did. There is no residuary clause under the will. There's no contingent beneficiary. Quite frankly, if I had been advising that client, I would have tried to advise them that it would be important that if you're going to leave your primary estate to people older than you, especially a generation older than you, that you name contingent beneficiaries. But that wasn't done here. So the persons who were to receive under the will, and the only persons that are specifically named, were Frank and Clara. They both predeceased Larry. So what happens now? Well, what happens now in the view of the court is application of the Kansas Anti-Lapse statute, which has been referred to liberally during the course of this proceeding. This is a law passed by the legislature of the state of Kansas to prevent people from being declared intestate. In other words, it's to give effect to wills even when a primary beneficiary passes away. Kansas's law is just relatively simple and says, well, then their descendants, their lineal descendants, will take their place without it's being stated in a will. By operation of law, the anti-lapse statute applies. The court rules at this time that Mr. Cranmer's arguments regarding the in re estate of Strobel are not applicable to this case. Strobel is legally and factually distinguishable. In Strobel, the beneficiaries in that case had to meet a precondition before anybody took under that will. In other words, they had to survive the testator, as the court recalls, by 30 days. And they didn't do that in that case. Therefore, since they, the primary beneficiaries, would have never received anything under the will, no one under them would receive under that will either. Therefore, the Kansas Anti-Lapse statute did not apply in that instance, and the property passed through intestate succession. The will lapsed in the Strobel case. There is a quote, and a very appropriate quote, that Mr. Mills put in his brief that I'm going to repeat at this point. This was from the estate of Russell, a 1975 case, and I'll try to go slow. In construing a will, courts must, A, arrive at the intention of the testator from an examination of the whole instrument, if consistent with rules of law, giving every single provision thereof a practical operative effect. B, uphold it if possible. C, avoid any interpretation resulting in intestacy when possible. D, give supreme importance to the intention of the testator. And E, where the language found in such instrument is clearly and unequivocally expressed, determine the intent and purpose of the testator without resort to rules of judicial construction applicable to the interpretation of an instrument which is uncertain, indefinite, and ambiguous in its terms. This will can be upheld by the assistance of the Kansas Anti-Lapse statute, which is intended to apply in this situation. The court can give meaning and effect to all of this will's terms. In essence, what happened here is that the will left the property to Franklin and Clara, Larry's parents. They died first. The anti-lapse statute then comes into play. And the question then becomes, is there any person who was issued a Frank and Clara who survives, who can step into Frank and Clara's shoes? Well, the answer is clearly yes. Mandolin is a grandchild of Frank and Clara, the child of Dennis, which was a child of Frank and Clara. So she's a granddaughter. So clearly, there is surviving issue. So this is not a will that lapses because there's nobody to leave it to. The Kansas Anti-Lapse statute intends that Mandolin steps into Frank and Clara's shoes. So the will can be carried out. Susan Davenport, if she can appropriately show paternity or parentage in this case, that she is linked to Frank and Clara as what would be a granddaughter in this instance, would also share in this estate. That is not clear. The court makes no ruling on that particular issue. Then the issue becomes, what about the children of Larry, which would be grandchildren of Frank and Clara? That would be Terry, Esma Pearl, whatever name we give her. She's one of those children. Frank is the other. To give effect to all provisions of the will, the court must look at the fact that Frank and Pearl were specifically, clearly, and unequivocally disinherited in this will. This court will not ignore the obvious intent of the testator, which took those two out. I am aware that I have two children, namely Terry Robertson and Frank Bly, and it is my will that neither child inherit under my will. He couldn't be more clear about their disinheritance. It is the ruling of the court that they do not come back in as a result of the anti-lapse statute, that to give effect to the will and its provisions, they are specifically disinherited because the will calls for that. And the anti-lapse statute makes it clear that that the court has to still follow specific provisions of the will when it comes to application of the anti-lapse statute. So the court rules that Pearl and Frank are out. However, this court also has to find that the language used in the will makes no mention of the issue or lineal descendants of Terry, Ezra Pearl, or Frank. And the court finds that it would have been really simple to add language to make that clear. For example, to state that my children and their issue are disinherited. My children and their lineal descendants are disinherited. My children and my grandchildren are specifically disinherited. But no such language appears. Mr. Mills would have this court simply imply that those are parts of the will. They are not. Those words are not there. This court cannot read them in. A language of disinheritance must be specific and clear as to the individual's disinherited. There is no clarity in this will that there was any intention to take out what the court would deem as innocent beneficiaries or innocent heirs who are not specifically disinherited. It does appear to the court that Pearl has 4 children. Am I right? 4? Victoria, Claire, Isaac, and Stuart.
That is correct, Your Honor. 4 children.
The court rules that those 4 would take what would otherwise be an appropriate share of this estate. Now, Victoria, Claire, Isaac, and Stuart are not grandchildren. This court views Frank and Pearl's disinheritance as legally dead. They are construed by this court to be predeceased when the court applies the anti-lapse statute. I hate to use the term, folks, but I think that it helps illustrate what happens in a situation like this. If indeed Pearl and Frank are legally dead, their children aren't. These children are not specifically disinherited. Therefore, they would take, the 4 children of Pearl would take and split their mother's share that she would have had she legally lived, which would be a granddaughter's share of either 1/2 or 1/3, depending on what comes out on the Susan Davenport situation. So it would be the court's ruling then that the children of Pearl are not specifically disinherited, and that they do take under the Kansas anti-lapse statutes as lineal descendants, not essentially of their parent, but of their great-grandparents, Frank and Clara. They haven't lost their status as great-grandchildren of the beneficiaries of this will, Frank and Clara. So I believe that the court's pronouncements this morning resolve most, if not all, issues in this case. The court directs the estate's attorney to carry out the court's ruling in regards to disposition of this particular estate. We still have a very important issue regarding the parentage of Susan Davenport. Obviously, if she is excluded, Mandolin would receive 1/2 of this estate. Victoria, Claire, Isaac, and Stuart, 12.5% in the view of the court. If Susan Davenport's included, then Mandolin would receive 1/3, Susan 1/3, and then the other kids would receive 1/12 of this estate. Mr. Mills, this court specifically rejects your argument that they have to file any type of claim or assert any type of entry into this proceeding to receive. Either they are beneficiaries under the will or they're not. Now, it very well may be appropriate for a number of reasons for them to disclaim their interest in this estate, but that has to be a voluntary act on their part. The estate's attorney would be directed to contact them and I suppose inquire as to what their intentions are regarding receipt or non-receipt of part of this estate. I suspect I know what their answer will be, but I think that's up to them. And obviously that would affect an ultimate outcome depending on what decisions they make. Mr. Webb, I'm curious, do you have viable addresses for each of these 4?
Yeah, we believe that we do. We have sent them notice of this hearing as well as notice of prior hearings, and my client is present with me in my office and says that she believes that she has accurate addresses.
All right.
And we will confirm that before we send a check.
If there needs to be an inquiry, I would sure she should be able to provide each of her children's current addresses, I would hope. All right. So let me address Ms. Williams at this point. We have an ongoing issue, and it's an important one as to whether your client even shares in this estate or not. This court would have to have proof provided to it, unless there's a concession, which I've never understood that there is, that she is one of the children that would receive. She would be the child of John Kennan, which is Clara Holderman's son, and she has to prove that. And I got an impression from Mr. Mills' submission that the adoption records were inconclusive.
Actually, the adoption records were very interesting, Judge. Basically, we obtained the adoption file and we obtained my client's pre-adoption birth certificate. In the adoption They state that the father is unknown. They give no notice. They don't publish anything. But back then, they would have a social worker, looked like maybe a SRS social worker, do a little investigation, a little bit write-up. And for some reason, this unknown person, they had a birth year and they knew his occupation was that of a jockey in Eureka. So then we go to the birth certificate where the father's information should be, and this is the pre-adoption birth certificate. You would assume that there'd be no name or the word unknown or someone's name. It wasn't any of those three. It said not unknown. Not unknown. So this gives credence to what my client had always been told, was that there were a couple of things going on. Her biological mother's family was rather embarrassed by this situation, felt like the biological father's family was of a different social class. And there was some embarrassment of that. And number two, there was an age difference. The mother was 17, the biological father was 21, and there were some threats that if he was named father, a bit came out that they might try to pursue getting him thrown into jail. So I think clearly they knew who the father was, but they did this shell game of pretending he didn't exist. Clearly they knew who he was. I have been working through trying to go from the least intrusive, least expensive ways of showing my clients paternity up to the more intrusive, more costly ways. I believe Mr. Wetta's client accepts my client as an heir. There is all kinds of family evidence, and including Mr. Mills's client has known my client since 1989, has met her several times, has called her cousin, but now doesn't once this has come up. There are pictures. My client was in the obituary. She is listed on the headstone as the daughter of Mr. Kennan. I realize that that is not DNA evidence. The local.
Okay, let me ask, who made the decisions to include her in an obituary on a headstone? Who made those calls?
I can tell you, Mr. Holderman, Frank Holderman, and Mr. Kennan's mother, the grandmother, the biological paternal grandmother.
Clara?
Yes, yes, sir. We've got pictures of the headstone listing her as daughter, the obituary listing her as daughter. Mr. Kennan acknowledged her as daughter. We have pictures of the family. I mean, everyone accepted that she was Mr. Kennan's daughter, including Mr. Kennan and Mr. Kennan's mother, who was an original heir to this will.
Well, apparently not everyone has accepted
Well,
that.
not everyone. Ms. Holderman is now not accepting that. So basically, I have looked at local, like utility consultants and their DNA. Do you want me to get into this at this time, Judge?
Well, your presentation's been excellent, and I understand now that you have a good faith factual basis to make.
Oh, absolutely. Yes, absolutely.
It does appear that there may need to be a trial on the merits on this issue if it's contested. I trust that you're going to provide any and all documentary evidence to the other attorneys involved in this case, particularly Mr. Wetta, Mr. Mills.
Absolutely.
I'm not sure exactly what interest Mr. Cranmer is going to have after today. But obviously, if he asks for that information to be shared with him, I will require it. And then if the parties are unable to reach an agreement on that issue, then it'll need to be set for trial, frankly.
Okay.
Where the burden of proof will be on you and your client to prove that she is a lineal descendant of Frank or Clara.
Well, yes, I think you're right. We're exploring the DNA possibilities, which starts getting us into the weeds a little bit. We can address that later, but yes, Judge, we are working through the steps, trying to go from least to most intrusive to try to figure this out.
Like exhuming a body.
Yes, Judge, that is what I'm getting to. Yes.
There's no other known source of DNA.
Yes, there is. And that's why I didn't know if you wanted me to continue. Let me tell you that first I tried like utility consultants, a local agency that does DNA testing. their tests are aimed to determine paternity. Therefore, they are not the most sensitive of tests. So if we had the putative father or the putative father's brother, something like that, we could use that. But in this case, all of that generation is deceased. We have like a great uncle, we may have a great aunt, we may have a cousin. So that's part of our problem. So then I think it comes down to either we use a site, a professional site such as ancestry.com or one of those type sites that has a much more sensitive test that can genetically link you with even your fourth cousins, and we accept that, or we start exhuming a body. And I hate to go there, but that would be the possibility that we exhume Mr. Kennan. Mr. Holderman, the gentleman whose will we've been dealing with, was cremated. My understanding is cremains can be tested. However, it is unlikely that they will give us a good result unless there's a great deal of bone marrow that survived the process. So it's unlikely that that would be a good source. So either we agree on a commercial testing site like I have described, or we look at exhuming Mr. Kennan. I've been trying to avoid that eventuality, Judge.
Mr. Weta, I presume that the estate's inventory has been filed in this case?
Yes, I believe it has, Your Honor.
I was trying to look at the financial viability of I've been discussed, and I see that there are substantial assets in this estate. And
yeah, and if I may interject, I don't mean to throw too much on. I think Joy has done an excellent job of presenting her client's case at this point. But it is my understanding from our construction of the family tree that Mr. Kennan is related to Clara only.
yes,
And I do think that will change our mathematics if she is indeed a beneficiary, given that she would only be entitled to half of the estate that would go to Clara through chapter 59-615, as she was not a lineal descendant of Franklin. So I do think that it would slightly change the mathematics, but I think we can get to that point if her client is able to show the evidence necessary to either by agreement or by trial, Your Honor.
and of course, I encourage the family to reach a family settlement agreement on these issues, if at all possible. But further discussions need to be held based on today's rulings of the court regarding the contested issues which are currently before it. So from here, Ms. Williams, how much time do you need? I think that Mr. Weta at some point would like to close this estate. I trust claim period is run, that the case might otherwise be in a position for final settlement if we can get these issues resolved. So what are you proposing here, Ms. Williams?
If we agree on using a commercial DNA website, it would take a few weeks to get the results back, but it would be, I would say 6 weeks, 6 to 8 weeks. If we are talking about exhuming Mr. Kennan, then that we would have to get the proper order to do that, exhume him. But then once we get the sample, it's a matter of getting it tested. I think maybe one of the more local testing sites could do it at that point, because then it's a paternity test, not trying to connect more far-flung relatives to each other. But we're talking a matter of probably a couple months.
All right, coordination of this many attorneys is problematic. So while I have everybody on this meeting, I'm going to have my assistant propose a date for status review. I'll allow an hour for this hearing. If there's some relatively quick and concise issue that the court can resolve, perhaps I can do it on that date. But I want to at least review the status. I don't want this case just to float off without any deadlines or court review. I'm looking at the last week of October, Mandy. Can you propose a date for an hour setting in the last week of October, and then we'll see if we can get it coordinated?
We are open the 30th.
All right, October 30, counsel?
Yes.
That works for me, Your Honor.
Your Honor, I don't, as you noted, I don't know how much involvement I'll have, but I have a trial down in Winfield on the 30th.
Okay. Court has made a final ruling regarding your clients and your clients' interests. If your trial goes off, I certainly invite your participation, but I think I'm going to go ahead, if that works for all the other attorneys, I think I'm going to go ahead and set it there. Certainly, if you need to have an attorney substitute just to weigh in on what the status of the case is, that's certainly appropriate, Mr. Cranmer, but I'm going to go ahead and look for a date on the 30th.
That's
Okay.
fine, Judge. I just wanted to let you know, and I can probably have Sam or somebody cover for me on that. I don't think I can take any action with regard to an appeal anyway until the whole case has been resolved. I'll need to research that, and I need to talk to my clients, but.
Okay, did I get clearance from Mills and Joy
Yes, Your
Williams
Honor.
and
The
Mr.
30th,
Wetta?
Your Honor, the 30th is good for me.
Okay, Mr.
Your
Wetta?
Honor- Oh, sorry.
Yeah, I'm sorry, Your Honor. Did you say what time on the 30th?
I was going to propose 10 a.m.
That's fine for me. Thank you, Your Honor.
Your Honor, I have a standing court appointment on Monday mornings. I'm usually not done until 11 or 11:30. So I don't know that I can make 10 o'clock work. I'm
Are
sorry.
you free up in the afternoon then?
Later in the afternoon, I could do probably a 3:30 or a 4.
Okay. 4 o'clock work for you, Mr. Mills?
Yes, Your Honor.
Mr. Wetta?
I'm available, Your Honor. Thank you.
October 30, 4 o'clock p.m. The court will set a status review. I'm going to primarily be reviewing the issue of parentage of Ms. Williams' client at that time. October 30th, 4 o'clock.
Your Honor, that's just a status conference, is that correct?
Yes.
Thank you, Your Honor.
Perhaps it'll be an announcement of the settlement that's been reached by the family in this case. Certainly agreeable with the court if that's what it's used for. October 30, 4 o'clock p.m. status review. I'm not necessarily interested, Mr. Wetta, in determining all proportions because that's undecided for any number of reasons. But if the basic rulings that were made here today, I'm going to assign you the responsibility of drafting it. You are essentially more or less a neutral party. As the attorney for the estate, I'm going to task you with drafting an order stemming from today regarding the various rulings that have been made by the court today. If you'll circulate that among all counsel.
Yes, Your Honor. Thank you.
Okay. Thank you, Mr. Wetta. Greatly appreciated. Some reference to exact proportions that the heirs would receive under this order is yet to be determined, or something along those lines would be adequate. All right. Mr. Cranmer, anything further we need to address today?
I have nothing further for today, Your Honor. Thank you.
Ms. Williams, anything further at this time?
No, Your Honor.
Mr. Mills?
No, Your Honor.
Okay. And Mr. Webb?
Nothing further, Your Honor. Thank you.
Very well. Thank you all for your involvement and the quality of your submissions to the court and arguments made here today. If there's nothing further, the Holderman matter will currently be in recess. And Mandy, you may end this meeting for all at this time.
Bye.